No government works are copyrightable. So if the government has created a work, it is not copyright protected. So all of the cases and all of the statutes and all of the CFRs and much of the information that you will find on government websites and web pages, the pros, can be taken and lifted, and you can do what you want with that. Now that's the general rule. There are some very limited the government that has a copyright symbol on it. What that probably will tell you is that the government has contracted out for that to be created, and it has allowed the people who they contracted with to keep the copyright. So, but with that very limited exception, those things that are created by government employees are not copyright protected in the first place. So there would be absolutely no problem putting any of that material into course materials that you would hand out, into whether you burn a CD. I believe tomorrow somebody's going to be talking about how to make CDs, or whether or not you were going to put it onto your web page. So that is the big first thing. Now, what is a copyright? It's nothing more than just a federally recognized right that is created by Congress. It's a form of intellectual property, and as a form of intellectual property, it is, in essence, protection for some creation of the mind. And this protection has a number of different aspects to it, but the primary aspect is that of a property right. And the property right, which is not really a single right, is more of a group of rights, allows the owner of that particular copyright to reproduce the work, to distribute the work, to publish the work, to perform the work, or to allow other people to create derivative works from that work. So an example of a derivative work would be perhaps if you have a novel, somebody writes a novel, and then somebody wants to make a movie from that novel. That would be not the exact same work, but it is certainly based upon the original novel, at least to some extent, more or less, depending upon the movie, I suppose. But what you will see is that the owner of the original underlying copyright can prohibit the changing of that work. Okay. Now, so at its touchstone, what copyrights protect is expression. So as we go through, and what I'm going to spend some time talking to you about next is some other things that are not copyrightable. But what we need to remember is that at its core, copyright law protects expression. So, for example, it is axiomatic that no facts can be copyrighted. So if you were to get a history textbook and want to copy the facts regarding the assassination of JFK, you could take those facts and do with them what you want. Okay, there are cases that say that even if it is somebody's theory, as long as they are putting it forward as if this is fact, it is being portrayed as fact, and you can take that as fact. So that which is being portrayed as fact can be taken. What you cannot do, however, is copy wholesale the verbiage from a particular historical textbook or any other textbook for that matter. Because while you can take the facts, when we put those facts into some kind of prose, that prose becomes protectable. Okay, so you can take the constituent elements as long as the constituent elements are not copyright protected. So that is one big, very important caveat. So I don't want anybody leaving here today saying, well, he said I could take, this fact, and then, because it's not all that simple. But facts are something that are clearly not copyright protected. Other things that are not copyright protected are titles, names, and short phrases, and slogans are not copyrighted. Now notice we're not mentioning trademark law. There may be some other trademark implications if you were to cut and paste somebody's trademark onto your website. But there is, in names, short titles, or phrases, there is no copyright protection. again, very important, no copyright protection in an idea. A mere idea is not copyrightable. So the fact that you have gone and you have seen somebody talk about something on the internet or in a book, or they have excited you to write about something that they have written about, or a topic or something of that nature, you are free to do that. Again, it is about protecting the expression of the party involved. So you cannot lift their expression, but you can take ideas. Ideas are not copyright protected. And of course, those works that are already in the public domain are free to be taken as copyrights. Now, what is in the public domain? That gets us into an idea of how long does copyright protection last. The general rule is if it's created during your lifetime, neither you, your children, nor your grandchildren, and maybe even your great-grandchildren, will see it in the public domain. Okay, so works that are created on or after January 1st, 1978, which are probably going to be the vast majority of the works that you're going to encounter on the web, at least currently. There are many efforts putting older documents up on the web, but much of what the web has to offer has been created after 1978, and the copyright on things after that point in time is the life of the author plus 70 years. Okay, so that's a general rule of thumb. So we're looking at, 5 or 6 generations probably before something's going to pass into the public domain, which is another issue altogether that maybe the Supreme Court will decide next term, when they've already taken a case that will look at that term to see if it is unconstitutional. But so one of the things you're going to want to do is you're going to want to, I think, always assume that when you encounter something on the web that it is copyrighted. Okay, now that leads me into another related concept. When is something copyrighted? It used to be true that in order for someone to claim a copyright, there had to be a copyright symbol on it and a clear indication that rights were being reserved. That's not true anymore. For about the last 12 or 15 years, that notice has not been required, which makes it exceptionally challenging, particularly on the internet, to know what is copyright, what people are going to claim is copyrighted, and what people are disseminating for the public to do what they will with. And there's no real easy way around that. The minute that something that is protectable is fixed in a tangible medium of expression, the copyright is attached. Okay, there is no need to have a copyright federally registered, okay, for the copyright itself to exist. If what you want to do is if you are creating something that you think is economically viable enough for somebody else to knock off and perhaps make money on, then you're going to want to get a federally registered copyright, because the only way that you can sue anybody is in federal court, and the ticket to get to federal court requires that copyright from the federal government. It's a very cheap and fairly easy thing to get. I think the cost is now $30. You fill out the forms, and if any of you have done that, when I say easy, you may be cringing. There's no review that is being done other than that you filled out the forms. But like with most government entities, if they have really nothing to do other than make sure you filled out the form correctly, they get very particular about the form, and sometimes it can take months to fill out the form to their satisfaction, going back and forth. But once you do that, you will get issued. There is no substantive review to determine whether or not you're entitled to a copyright, which is another problem. So if you encounter a work that has already passed into the public domain and somebody is claiming a copyright on it, I mean, there are some kind of anomalies that can happen. Or people will, a big area, a lot of people will try and claim copyrights in what are called blank forms. And blank forms are not copyrightable. Okay, forms that convey meaning are copyrightable. Okay, and for our purposes, we could not go and just copy a workbook that we found, let's say maybe from Westlaw, and say these are some really nice questions. I'm going to put them up on the internet, and this is really in a workbook format or a form format, or what have you. No, you can't do that kind of thing. And if I could backtrack just for a second, when I say you can take cases and statutes and so forth, I am not saying you can download these things off of Westlaw. Okay, Westlaw has got some meaningful copyrights that you would be violating if you did that and then distribute them. While the part that the judges write in cases, for example, is not copyright protected, the head notes in Westlaw are copyright protected. Having said that, most of our user agreements with Westlaw require us to agree, if you've taken the time to read them, or if you want to go back and look at yours, require that you agree not to download things off of Westlaw to then distribute. Okay, so while you would not be under copyright law violating taking the case from Westlaw, you would probably be violating your user agreement with Westlaw. But that is becoming less and less important as more and more places on the internet are putting up cases that we can get to. And one great site for cases and for statutes and for all kinds of legal information is findlaw.com, and some of you probably already know about it. And it seems like they get more and more cases up there all the time. And now the Supreme Court is also digitizing, and they're putting their decisions the same day that they're released up on the internet in PDF format. Now, if you're going to use those cases that you get from the Supreme Court in PDF format, I would give you a word to the wise. I don't know how it's ultimately going to play out, but right now, after a decision gets old, and I'm not sure what that means yet, they no longer publish the one decision in a PDF format. They publish the entire bound volume together. So then in order to access that decision in PDF format, you would have to go in and take it out of the entire bound volume, which can be difficult. So if you come across from the Supreme Court a decision that you think is important that you would like to have in a computer-generated format, in PDF is fine, which is the Acrobat Reader type file. What I would suggest you do is save it to your hard drive so that it can be easily accessible. So more and more courts are going online and getting easier to use. The Fifth Circuit has been online for a while, and it's quite easy to use. The Ninth Circuit, the cases they put online, as far as I can tell, are almost impossible to use and read, and footnotes everywhere, and the pagination doesn't make sense. There are more and more courts moving to this online format, so that there are a lot of cases out there that we do not have to rely simply on getting them off of Westlaw, running the risk of violating our user agreements.
Well, what about Lexis? Yes, the Lexis user agreement.
That I don't know, because I know little or nothing about Lexis. I will admit to being a Westlaw. I'm not sure I'm a Westlaw fan. It's just that that's all that I've used. I would imagine that their agreement is probably very, very similar. But there are many, many sites on the internet, so I would encourage you to look for the sites. Particularly, FindLaw has got tremendous amounts of information on there. Okay, so we've talked about what is not copyrighted. Now, pretty much anything that we are going to want to provide for our students on a course website is going to be copyright protectable. Okay, meaning the subject matter for copyrights is pretty broad. It covers any kind of writing, covers any kind of pictures, covers any kind of really audio or video. So if what you're looking to do is you're looking to put some work that somebody has made and put it completely on your website, copy it onto your website, I want you to think that what we're dealing with is protectable expression. It is copyrightable. So the question isn't, can I take all of it? The question that I would like you to think is, well, what can I take from this? Can I take the part that the judge has written? Can I take the facts from it and write my own kind of summary, or what have you? Now, there are two concepts that are important. One is linking and one is the copying. Okay? Linking does not get us into problems, really. We'll talk about that in a minute. For academics, for most of the stuff that we're going to do, linking is going to be completely fine. Let me take a moment I should have explained this at the very beginning. We all come from very different institutions, and a lot of what we're going to be doing is going to be driven by the policies of our own institution. So I'm giving you the general overview and telling you what, in my opinion, we can do and what we can get away with, and I'm trying to give you as straight and fair advice as I possibly can. Now, because of vicarious liability concerns, your home institution and the attorneys that represent them, whether or not they are risk adverse or whether they are risk takers, may see things in a different way. I don't think with respect to linking they will, but with respect to what I've told you about, you can go out and you can copy all this stuff that's in the public domain. They may be uncomfortable with you doing it. I actually for a while worked for an institution in Florida that was very adverse to any implications that what was going on was copied, even if what you were doing was clearly not violating the Copyright Act. So I want to explain that to you. So before you go out and do this, you may want to check with the policies of your own particular institution to feel what their comfort level is. Because a lot of the websites that you see for academics are going to be sites that are provided from the university themselves. Now, more and more of us are going on and getting our own websites, like I've done with IP Watchdog, and you see that becoming more and more popular. In doing something like this, there's probably people here who are going to talk about this today. It's not very expensive, really. Getting your own domain name is $35 a year. Getting a web hosting company that I just switched to Earthlink, and I think it's $30 a month for 200 megabyte site, which is huge, and it's cheaper if you move down from there. So for a nominal fee, you can have your own website, and you can do this. I do this website in Front Page, so it's not the world's most expensive web developing program, and there are other even cheaper programs that you can use to accomplish, or you can even create your own web pages in Word or WordPerfect as well, if all what you want to do is just about links. So it is getting much easier for us to get onto the web, and we may have some more flexibility if your home institution doesn't allow you to do it off of their website. If you go and get your own website, there may be some more flexibility there. I'll leave that to you and to ask your institutions. Now, with respect to the linking, though, versus the copying, what will get you in trouble is going and saying there's no difference between the two, because there is a difference. When we link, we provide a link. What is happening is, as far as the copyright law is concerned, no copy is being made. Right now, there is a case out there that goes to the contrary and says the opposite. And if those of you are familiar with Intellectual Reserve v. Utah Lighthouse Ministry, in that particular case, the court said that the link was copyright infringing because when the technology, in order for the internet to work, what winds up happening is when you link somewhere, it goes out into the internet and it pulls it back into your browser. Now, all along the way, as it goes from my server to your browser, there may be copies that are made. Okay, now those copies are usually transient copies that don't get stored for any appreciable period of time, but they're copies nonetheless. That's the way that the internet has to work for technological purposes. And if you're a techie, I have just way oversimplified it. I know. All right, but what happens is all throughout the way, there are many copies that are being made. So this one particular court has said that in and of itself means that hyperlinking is copyright infringement. No other court in the country has adopted that rationale, and pretty much every other court that has had the opportunity to discuss that has completely rejected that rationale and has said that hyperlinking in and of itself is completely fine. Okay, now that's direct hyperlinking. Now, what happens when you hyperlink is you'll click on Let me just do this here. I'll click on this frequently asked questions here. And what I do is I'm taking to another web page, and this actually is something that's off of my web page. It could have been something that was off of another web page. And it pops up. Okay, now what it looks like is this is just a part of the same website that we were on, okay, in the same server. Well, in this instance it is. Okay, but if we go back and we click on copyright basics here, or let's just click on U.S. copyright laws. Although it may look like it is the same logical extension of my website, I have gone to a completely different website that's now hosted by the government. Okay. Now this type of linking is completely fine. There's nothing wrong with this linking whatsoever. All right. So hyperlinking in and of itself is not a problem. Now, if what I had done was, and it is possible to do this, as I'm sure many of you know, you go onto this page and you see something that you like and you copy it, and then you save it to your server. Okay, now we have a copyright problem. Now we have a copyright infringement problem, because what you have actually done is taken protected speech and copied it. Okay, and you've copied it to your particular server. Now, for much of the stuff, obviously this is the government website, so we wouldn't have those concerns with this particular website. But let's say you did this with the New York Times, for example. You see an article that you like, that you want to make sure that you have available, and if you know the New York Times, the more power that they seem to get on the internet and the more users that they get, the more they try and hide their articles, and they vanish after a day and you can't find them, and then you have to pay a subscription fee in order to get out of the archive. So you come across an article in the New York Times that you like, and today it's freely available for everybody. So what you do is you click it, save it onto your computer, upload it to your server, so that way you always have access to that article. Well, that's very, very different than hyperlinking that article, because you have actually physically copied it. And with the rights that go to the copyright owner also go the rights not just to publish, but the right to decide not to publish, the right to withdraw from publication, and the right to take away. And if any of you have kids, you probably know this phenomenon with Disney. Disney does it to a wonderful degree. If you are a marketing person, they will put these tapes out for a while, and then they will go away and disappear, and then they'll come back 3 or 4 years later or a decade later, and everybody's got to have them now again, and Disney makes their money all over again. So with the right to publish also comes the right not to publish, or the right to take away. So if you are circumventing those kinds of rights, it is copyright infringement. So when I'm talking about linking here, I'm not talking about things that look like linking are okay. I'm actually saying linking from your site to somebody else's site, taking your user from your site, putting them now in charge, in this instance with the Copyright Office, that is okay. There's no problem with that. And for most of our purposes, that's probably all we have to do. Now, the other thing in this instance, since it is a government site, there is a lot of information here, and a lot of the information that I put on this CD for you, I copied from this website, okay, and put on here, and that is completely fine. Okay, because it is not copyright protected, so I don't have to worry about them coming after me. Another important area of things that we can copy, at least in the real world, are going to be law review articles. Pretty much every journal that I know of, that I'm familiar with, as long as you do not charge more than the cost of the copy, has an agreement with the authors that you give anybody the right to copy those for student use and for classroom use. Again, as long as it doesn't cost the student more than the cost of copy. Okay, I'm not completely sure that that's going to be the case with respect to copying articles in digital form and posting them to your website, because what you're doing now, more and more of these law journals are doing that themselves. And they're using that as a tool in order to get you to go to their site and to link people to their site. The thing with linking here is if people want to have the opportunity to attract the user themselves, Okay, so linking provides that opportunity. If what you do is you start linking in a way that creates framing, and those of you who may be familiar with framing, which isn't so much of a problem now because technology can defeat framing, but if you were to frame this link in a certain way to make it look like you did it, so what you've done is you framed out the identification of where it really came from. Now, we probably don't have a copyright problem, but we probably do have a trademark problem. Okay? And under the latest decision from the Ninth Circuit in CALI v. Ariba, we may also have a copyright problem, but I think that that's unclear. They use the word framing in that situation, but I don't believe they're talking about the traditional, those of you who are familiar with the framing, the trademark cases. What CALI v. Ariba is talking about is what is called inline linking. Inline linking is, at least now in the Ninth Circuit, violative of copyrights. Okay, now, the best example I can give you of, actually, let me see, I didn't pull this site up. I have an example here of inline. Okay. This actually doesn't come up so well here. This is an image here that now, does everybody see how this looks like that I've copied this image from, and I picked an image that was not copyright protected. I didn't want to infringe anybody's copyright in this demonstration. But this image now appears as if it is on my website. The same as all the other images. Okay, these images up at the top, the IP watchdog and the inline linking, they are on my server. This one is not. Okay, now the way that you can check this is if you go with your cursor and you right-click over the cursor, go down to Properties, what you will have, and I explained this here on this page as well. Go to Properties, it will pop up somewhere the address, and it's that image is on the Copyright Office's server. Okay, so what I'm doing is when this website pulls up, what winds up happening is I suck in that image from a different server and put it onto my website. Okay, and it looks like this is on my website. It looks the same as if I had copied it and pasted it there. Okay, what the Ninth Circuit has said is this kind of inline linking violates the copyright owner's right to display. Because not only, then what you need to do is you need to think of the copyright not as just any one particular right. It really is a bundle of rights. The right to publish, the right to copy, the right to reproduce, the right to distribute, the right not to do all of those things if you so choose, and also the right to display. And on the internet, the right to display is arguably one of the more important of the rights given the particular medium. Now there's been a lot, if those of you are familiar with this debate, in the academic world there's been a criticism of this being copyright infringement for quite a while. I had always thought it was only a matter of time whether or not this really is intellectually copyright infringement or not. It was only a matter of time before some court said that it was. So if you are going to if you're going to do this kind of inline linking, suck it into your website like this, you're going to run a risk of violating copyright laws. And if you were to do it with a trademark, or if you're going to do it with a trademark, you'd also be violating trademark laws as well. So you want to stay away from those types of things. In the case, this may not be such a big problem for us in the legal world. This would be a much larger problem for museums and a much larger problem for art history departments who want to, those types of professors who want to have pictures on their websites, because the CALI v. Ariba case deals with photographs. Okay, so this is not okay. So when we say linking is okay, we're talking about just taking from your site, putting your user on another site. That's okay. There's what's called deep linking as well. What deep linking is it bypasses the home page. So if you were to link from one page, what we just had up here was an example of a deep link. When I go to this website, my website here and I click on U.S. copyright law, and this comes up, this is a deep link. A link that takes you past the home page is a deep link. Okay, and this is past the Copyright Office's homepage is copyright.gov. Okay, and this page that we just pulled up is copyright.gov/laws. Okay, that's a deep link. Deep links are not violative of copyrights, but they may violate contracts. They may violate user agreements. And there are the case that deals with this probably most directly. They're very short cases, and again, it's on the CD. If you want to pick it up, is Ticketmaster versus Tickets.com. And what Tickets.com did is when they were trying to sell tickets, they wanted people to be able to go to their website for all of their ticket needs. And they didn't sell all of the tickets to everything everybody would want because Ticketmaster has many exclusive deals. So what they would do is they would deep link from their web page directly to Ticketmaster for particular events. And then Ticketmaster would make the sale. So the Ticketmaster's losing no revenue directly off the sale of the tickets, but Ticketmaster was upset because of it being a deep link. So one of the ways that a lot of folks are making, some folks are making money on the internet is still through advertising. Okay? Despite what you read in the papers, advertising does make money for people on the internet, and it makes a lot of money, and it's going to make more and more money as our right of privacy continues to be invaded and people profiling. You ever wonder how you go to these big websites and all the ads that pop up deal with, wow, that's very interesting. That's very interesting to me. How do every time I go to this website, they know that I like camping and mountain biking and rock climbing, because all the ads are about that, right? Well, it's profiling. So the ads do make people money, and they're getting better and better at profiling. So I think ad revenue will go up, or at least for the bigger sites. And for Ticketmaster.com, where people will go to that site anyway, if they can force you to work your way through the website in the order that they want you to, they can maximize the number of ads that you see. And by maximizing the number of ads you see, depending upon how they're charging for ads, they can raise their revenue. If they're getting paid by how much every time somebody sees the ad, which is not too common, but that obviously the more people that see the ads, the better off. And the more ads that you see, the more likely it is that you'll see one that you like and you may actually click on it, in which case they'll get paid as well. So this deep linking has been an issue in a number of cases because of that. And as we're going to talk about in a minute when we get to fair use, the general rule of thumb is if you're doing something that costs the copyright owner money, it's copyright infringement. Okay, that's a general rule of thumb. It's a way oversimplified rule of thumb, but if you're going to try and boil it down to one question, that's the one question. If you're costing them money, it's copyright infringement. Okay, now that has not worked with respect to deep linking. Okay, so even though that these people can make arguments to say that because of your deep linking, you're bypassing my advertising, no court has found that to be persuasive. So deep linking is okay. So far we know deep linking is okay, linking directly to a home page is okay, inline linking stay away from. I would also stay away from frames, and if you don't know what frames are, then don't even worry about it. Okay, stay away from them. And it really is a waste to use them anymore because so much technology will defeat the frame anyway. So linking is good. We can take cases that we find. A lot of times I will find cases on FindLaw and copy them and then put them into a word processing document, edit out the FindLaw material, and then post it to my site or copy it and distribute it, because FindLaw doesn't have a copyright on the case part. They don't have a copyright on the statutes. Okay, they don't have any of that type of material. I've started moving away from doing that with FindLaw lately to some extent because it's always there. It seems like it's going to be a reliable source. But if you come across a source on the internet that does have that kind of information, I would suggest that you take it, because one of the things that we see on the internet, sites go up and sites go down, and they do change the format. So if it is something that is not copyright protected that you're going to want for future use, grab a hold of it and then save it. Does anybody have any questions about what we talked about so far, yes.
In the area of, you can say that framing is easily defeated by a webmaster. In other words, it'll refuse to bring something into a frame and instead open it up in a separate window. And we also know that deep linking can be defeated by webmasters. You know,
Yes.
just saying you're not allowed to get here from there.
Right.
If you want to get there, you've got to come in from our homepage. Should those capabilities be taken into account by courts and the burden shifted as a result and saying, well, you could have prevented this, but you didn't, and therefore, I'm wondering if these kinds of behavior should affect some legal change.
Well, I think that it probably would have, except for what we see is most of the courts are saying that if you want to do this, resort to self-help, because with respect to at least with respect to framing and with respect to hyperlinking and with respect to deep linking, the courts are not really entertaining those as legal problems, with the exception of if you frame it in a way that makes it look like it's yours and it's not yours, then you have a trademark problem. Okay. Now, I think where you have some more merit to your argument is with the inline linking, and say that inline linking could certainly be defeated by web pages if they want. And actually, the first example I tried to put together on the internet I couldn't use. It was I was looking for something that wasn't going to infringe as an example. And the University of Toledo on my faculty page, which is still up from last year, has a picture of me. And I figured, well, it's a picture of me that I took that I gave Toledo. There's no way that this could be infringed. So but I went and tried to link to that, and I could not. So the webmasters can prevent you from getting access to these files for purposes of this inline linking. What is going to wind up happening with this inline linking decision and whether or not that is going to continue to be copyright infringement, I have no idea, because the CALI v. Ariba case is really the first case that talks about it, and it's only probably about 5 months old. Now, all of the academic literature on it has for years said that there was absolutely no problem whatsoever. And the district court thought that the inline linking was, while it was not, the district court didn't want to say it was no problem, they said it wasn't fair use. So what's going to wind up happening with that, I really don't know. I think you make an excellent point there, and if any of the recent Supreme Court First Amendment cases give any guidance, it seems like the Supreme Court is big into self-help. And if you want to do it yourself. Don't bother us. So I think that you're right. But for the time being, to err on the side of caution, at least in the Ninth Circuit, inline linking is going to be copyright infringement. So I would suggest, since we probably really don't need to do that for ourselves, being legal academics, I would stay away from that. Yes?
I have a question. If you download something, you go to a page, say you download it to your computer.
Yes.
There are in temporary internet files. You have images and everything else.
Yes.
How does that affect?
Okay. The question was when you go and you go to I think I'll rephrase it.
Any page.
You go to any page on the web and you pull it up. It gets copied into your temporary internet file folder. And the question is that in and of itself copyright infringement? And that was exactly what the court in the Utah Lighthouse case said. It's because of these intermediate copies that get copied. And it's not just, that will not just be copied on your computer so that you can do it. It will be copied sometimes many times throughout. Maybe if it's a page that your internet service provider has a lot of folks wanting to look at, there's probably a copy of it that is residing on their machine as well, so that it can be accessed easier and quicker. No court other than them have said that is copyright infringement, even though it is a copy. Those kinds of RAM copies or copies in storage that are necessary for the technology to work are not copyright infringement. I feel very comfortable telling you that.
You're going to push to go in there and...
Yeah, even though it is really technically a copy on your machine. Yes?
Yeah, we've been talking about materials that have been put up on a site like yours, which is IPWatchdog.com, that clearly anyone can get to, so that would constitute a publication. The last major revision to the copyright statute was in 1976, and statutorily, there was an exception carved out for photocopying for classroom purposes.
Yes.
And I'm not aware of any cases that you can point to where the judiciary has said, these are the contours of the classroom exception in using web material. But I think you can draw an analogy to the photocopying. And I think part of the problem with people sitting in this room is that this is really a gray area, that the courts really haven't spoken to what it is that we all do.
Right, and I think that that's exactly correct. And that gets me into the whole fair use idea. Because one of the problems that we see on the internet is we're really left guessing to a large extent. So far, I've covered all the stuff that, I promised I was going to give you some bright line rules. You've got them, okay? Now we're going to take the step into what I don't know, what's going to happen. Because you're right, there are some, and again, on this CD, if you pick it up on the way out, Copyright Office issues what they call information circulars. Circular 21 is about, let me see, I'll give you the title here, if I can find it. It has the teaching guidelines in there. Reproduction of copyrighted works by educators and librarians. Okay, that information circular is probably the most important thing if you're going to be doing this to take a look at. Not just, it has no applicability to the web directly. It has a lot of applicability to all of the types of copying that we do in the real world. Now, there are guidelines in there that say that if what we want to do is we want to copy things that we find that are copyright protected, we can do that for distributing in the classroom. And there are some guidelines that go along with that says it must be only a brief portion and it must be spontaneous. That pretty much is it in a nutshell. And brevity and spontaneity are defined in the guidelines. Now, these guidelines are not law. What they are is at the time of the 1976 Copyright Act, the industry groups got together and came out with, because Congress was very worried that people like us were not going to be able to use copyrighted materials in classrooms. So they got everybody together, they came out with an agreement. Most of us violate the agreement every day that we photocopy stuff and hand out in class. The agreement is quite restrictive. Now, the agreement is not the complete contours to what we can get away with. The agreement is really only a safe harbor. The contours for where we can get away with things are found in Title 17, Section 107, which is the general variety vanilla applicable fair use section. Okay, and fair use is about as clear as mud. The one thing that as you go through, and this is where you're going to have problems with your home institution. If you're going to be doing some of the things that we've already talked about, or you're going to try and do something that's clearly covered by the guidelines, they're not going to have a problem. The problem is that is a very restrictive interpretation of what it is you can get away with. Fair use looks to see whether or not the use that we are trying to do, what we're trying to take, we are taking something that is copyrighted. Is that a use that should be permitted? And it is a four-factor test. And like any other test, a four-factor test, it can go anywhere based on any given facts, depending upon who the judge is and probably what they had for breakfast. The first factor is the purpose and character of the use. And weighed heavily is whether it's a commercial use or a not-for-profit educational use. Okay, so for most of the stuff that we do, even if we were to photocopy a complete article and pass it out in class, we would be very well, in very good stead under the first fair use factor because it is for academic use. Now, compare and contrast that with if we were photocopying the materials and then making a profit, doing what Kinko's does. Okay, now that's why Kinko's got in trouble. Okay, because it was a for-profit educational use. If it's a not-for-profit educational use, we're going to be okay. And we will also be okay usually under the fourth factor. The first and the fourth factor usually are very similar, which is the effect of the use upon the potential market for the copyrighted work. And that is another way of looking at whether or not there has been commercial damage to the author. Okay, if there is damage or potential damage to the author, it's going to weigh against the particular type of use. The second factor is the nature of the copyrighted work. Now, what does that mean? I don't know. I can tell you what most courts think it means. What most courts think it means is that the copyright owner wins that factor. Okay? The nature of the copyrighted work the cases say that there are some works that are more deserving of copyright protection than other works. You know, what that means, I have no idea, because as far as I read the statute, virtually everything is, I mean, sculptures, paintings, novels, poems, songs, lyrics, music, choreography, architect, I mean, it's all copyrightable. Now, how do we decide under Factor 2 what is more worthy, particularly in light of the fact that Supreme Court cases and many courts that have addressed it say that courts should not get involved in a comparative value of whether this really is art in determining whether anything is copyrighted. So usually the second factor goes in favor of the copyright owner. The third factor is the amount and substantiality of the portion used in relation to the whole. Okay, so under that factor we look at the quantity and the quality of what is taken, and this is where it gets really muddy for us. Okay, and this is why when we look at the teaching guidelines in Circular 21, they're the safe harbor. The Supreme Court has been all over the spectrum on what amount and substantiality of the portion used means. In Sony, many of you are probably familiar with the Sony, the VCR case. The Supreme Court said you could copy 100% and it's a fair use because all you're doing is time shifting. Okay, the Supreme Court has also said in Harper and Row, that's the Gerald Ford case, his memoirs case, the magazine that copies 300 words out of his memoirs has committed copyright infringement because they have taken the heart of the book. Okay, now if you're President Ford, I'm not sure I like that decision. There's only 300 words. But I mean, they say that tongue-in-cheek, but when you look at what they took the 300 words verbatim that dealt with his explanation of why he pardoned Richard Nixon. Okay, so from a marketing perspective, that was the hook. That was the hook for this book, and not only the book, Time Magazine had entered into an exclusive deal with the book publishers to get to publish that. So it was going to benefit the book publishers. Time Magazine writes about it, and the book gets publicity, and Time Magazine paid for the ability to put that juicy stuff in there, and then they were scooped. Okay, so it's copyright infringement. So this amount and substantiality of the portion used can really go all over the planet. The more that you use, the worse off you are. Okay, so that is. I've got 3 general principles with respect to fair use that can give us some kind of a guidance. One is the more that you take, the less likely it is of fair use. Okay, now again, the teaching guidelines are very, very restrictive. I've never interpreted them to mean exactly. I've interpreted them as a safe harbor. If you're taking a chapter out of a book and it's a 20 chapter book and you're photocopying one chapter, there's many lawyers that are going to tell you you're copyright infringement. I don't see it that way. We're going to be good on the first factor. We're probably going to be good on the fourth factor. The second factor goes to the copyright owner, and one chapter out of 20 for an academic use that's certainly going to guide this whole analysis. I think we're going to be okay. Now we take half the chapters of the book. Now we got problems. One of the big things with this amount of substantiality that's being taken, we want to ask is what are you taking? Is what you're taking a substitute for the copyrighted work? If what you are taking could be perceived, the more likely it is perceived as a substitute, the more likely it is not fair use, the more likely you're going to be an infringer. The other general rule is if it takes money out of the copyright owner's pocket, it is probably not fair use. We've said that. The third general fair use rule is giving the author credit does not get you off the hook. And having said that, there is this misperception, maybe not for people in this room, but that if it is on the internet, it is in the public domain, and that is just not true. Okay, and as we talked about earlier, people do not have to use the copyright notice anymore, so it is very difficult to know. I got 2 questions. You had 1 and then 2. Go ahead.
I got 2 things. One is in terms of taking money out of their pockets, with the increased use of the Copyright Clearance Center and the increased use of getting permissions for electronic reserves, I think that has to be taken into consideration because some of the courts have said that is a valid entitlement.
Yes.
So if you just decide to copy an article, you may still.
Yes, and let me focus on it, because under the guidelines, and this is the part of the guidelines that I think that I would say is more of a true rule than just a suggested manufacturer's retail price. Is it talks about spontaneity, and with respect to spontaneity, what it requires is you are copying this and using it so close in time that getting permission is not realistic. Okay, because there's no way to get a response. Okay, so now, having said it, you can't be spontaneous every semester with the same article. All right? I know that that's what the law says. I appreciate all of you are laughing and saying, yes, I can be, and I am. I'm spontaneous too. You're scrambling to say, oh, geez, I thought I had to sign this. Wasn't this in the book? The latest edition edited this out. You know, whatever. But if what you're doing is your own course materials, you can't claim the spontaneity exception year after year after year. The other thing, too, is anytime you can ask to get permission, you will be amazed at how many people are going to give us permission. I personally have been amazed. And most of the time, I ask somebody if I can put their stuff up on the internet on my site, and they're like, well, what do you want to do it for? And I say, I teach and I have this resource on the internet. And they're honored, they're flattered that I am actually assigning their work as reading. So whenever possible, I would get permission. Now, this is another thing I'm going to differ with your lawyers who are going to advise the university presidents and deans. Are going to say, well, don't go and get permission, because then if you get denied, you can't use it. Well, the beauty about permission is if it's denied, I can still say I have the fair use right to do it. And being denied permission is irrelevant. So I always encourage people to try and get permission first. Yes?
One chapter out of 20. How about one article out of 150 in today's newspaper?
If we do it spontaneously, I think you're going to be fine. And I'm pretty sure I know that that's not what the teaching guidelines say. But, excuse me, I think you are going to be okay with that. The big difference, though, is with respect to the internet, is when you go, and now that these articles can be archived, and if you copy it and put it up on your site, you are now a substitute with respect to this, at least that article. Because now New York Times, I think it was $250 or $350 for an archived article, it's probably only going to go up. But if you're doing it for a limited time, and this goes back to the question we had in the back, let me weave this in, because one of the things that you can do, if you're willing to run, and I don't think it's a great risk, but we know we can get away with what the teaching guidelines say, and we know we can get away with more than what the teaching guidelines say, because the teaching guidelines are not a straight implementation of fair use. So we still have this fair use that is very, very powerful for academics. So how can we make our websites look like what we know we can do in the classroom? And one good way is with password protection. Okay, now I can't tell you that there's any case that says that that's going to work, because I don't know of any case that says that. But I would be very comfortable making the argument, if I have limited this stuff to the people who are in my class, and I've copied it and put it onto the internet, and if I was able to copy it and hand it out in class, I've done nothing different. And now that argument has not been vetted. It's only a matter of time before it is. But then again, neither has distance learning. Distance learning has got tremendous problems with it. One of the things not so problematic for us, but is if you want to show a video or do a performance in your classroom live, or on videotape, Section 110 of the Copyright Act, 17 U.S.C. 110, gives us the right to do that with respect to quote-unquote face-to-face teaching activities. All right, so clearly 110 does not apply, and the legislative history doesn't anticipate the internet. So it doesn't apply to the internet. So right now everybody's studying, quote-unquote, studying the problem. Nobody's really done or said anything meaningful about the problem. So these issues are in flux, but to the extent that you're wanting to try that, make it look as much like what you can do in the classroom as possible. Yes?
Yeah, I guess we only have 4 minutes or so, but there are 2 things. One is that you haven't touched on, which I think is one of the most contentious issues right now for academics, and that is the relationship between the academic and his or her employer.
Yes.
In terms of ownership of course content put online. Universities across the country are increasingly insisting on their authorship of the course, that is the appropriation of that copyright, or demanding the assignment of the copyright as a condition of employment, or characterizing their faculty course material as work for hire. These are, to me, it sounds the death knell for higher education as we know it.
I agree.
Okay, that's one question. The second one, going back to the very beginning, when you talk about copyright deals with expression, not with ideas. In 1979, if we were together and talking about patents, we would say a patent, again, from the Constitution, has to be an invention.
Right.
Okay? A year later, in the Chakrabarty decision, the Supreme Court said that you can patent life forms. So everybody's patenting genes, sequences, which are not inventions.
Well, being a patent attorney might take exception, but I get your point. I know where you're going.
Well, let's just
we have no idea what the court's going to wind up doing.
Tomorrow they might say you can copyright ideas.
Yeah.
If they're good ideas.
Well, I mean, with this particular Supreme Court, I'm not going to make any bets on that. I can tell you, this whole idea of not being able to copyright ideas and it has to be original and all of these things are about tried and true legal principles that have been around for as long as our country's been around. I mean, the cases time after time after time have interpreted those as being constitutional requirements. Now, what's going to wind up happening, you're right. I don't know. I can't give you any real guidance on that other than to say that I've seen no evidence of them wavering from that. Now, with your first question, that wasn't so much an issue that I had anticipated talking about, but it is a big issue that has even less of an answer than what any of the rest of the stuff we have is. I would say there are some cases, and if you do a search on West, actually, if you're interested in this, email me. My email address is on the website, and because I have looked into this myself, and there are some cases that I can send you cites to that I don't have with me today that address this. And courts have characterized in much the same way that you have that this has never been the case. The universities have never gotten the copyrights, and that it very well could be the death knell of academic research. Now, as far as characterizing it as a work for hire, I think that is a horrible argument with respect to course materials that we put together. And the argument that I would use, and I will tell you today, is where in our description does it say we have to put together course materials? Does anybody have a contract that requires them to put together course materials? I mean, it probably is going to require you to adopt a textbook. Okay, so I would say that this goes beyond the scope of your employment, it goes beyond the scope of your employment contract. Now, and if there is not a clear written agreement, it cannot be a work for hire. If there's no agreement, no contract, it is not a work for hire. This is not and it cannot be a post hoc agreement. It has to be an agreement in front that says that this is a work for hire. Otherwise, it would have been an assignment. Okay, now, depending upon whether you're tenured or you're not tenured, say, I'm not tenured, I visit everywhere, so I'm looking for a job, so I don't usually rock too many boats, but for those of you out there who've already got tenure, there are some powerful arguments that I would be more than happy to share with you if you send me an email. Did I just say all